Welcome back to the channel, everyone. I know it's been a while since my last video, but that's because there has been so much stuff that has been happening lately. Today I wanted to talk briefly about the Bruen decision and what it means, not just for us throughout the nation, but also specifically here in California gun owners, of course, and what you can expect to see in the coming weeks, months, as a result of that decision. So for those of you that are unfamiliar with the case, New York State Rifle and Pistol Association v. Bruen. Why is it called Bruen? That's actually a question I saw on the forums here in California. I thought it was a good question. Admittedly, I have no idea why we're calling it Bruen, or at least that's just seems to be the accepted practice. My guess, of course, is because it's easier to say Bruen than it is New York State Rifle and Pistol Association. You know, less syllables. Everyone knows what the Bruen case is for the most part, so that's why it's being called Bruen. But other than that, I really have no idea. So what is the case about? Well, so Bruen was a case that challenged New York's proper cause requirement for the issuance of a CCW. You can very much equate proper cause in New York to California's good cause requirement. It's essentially the same thing, where basically, in New York at least, citizens that were applying for a CCW permit had to demonstrate a need that was distinguishable from that of the general public in order to get a CCW. Mere things like self-defense, I want to exercise my right to carry, was not acceptable, generally speaking, for the issuance of a CCW in New York. And so that case challenged that requirement, and the Supreme Court took up the case, and they recently issued a decision on June 23rd. And there's really two main takeaways from that decision that I wanted to highlight here today. The first one, of course, is that any sort of subjective requirement, one where a government official can sort of determine on their own and make up their own standards for the issuance of a CCW, is unconstitutional. So, moving forward here, a CCW issuing authority, whether it be in New York or any other state, can't sort of apply their own subjective criteria in determining whether or not to issue a CCW. The second, I think, more important takeaway here from the Bruen case is that we now have a standard of review for future Second Amendment cases. So what I mean by that is that in the wake of District of Columbia v. Heller and McDonald v. City of Chicago, the two former cases that we had at the Supreme Court that really touched on Second Amendment issues, both in 2008 and subsequently 2010, didn't really lay out a framework for courts to analyze Second Amendment related questions. And so what you had in the wake of Heller and McDonald were all the various courts sort of making it up as they go along, and obviously depending on the political makeup of the court, you got varying interpretations of how Second Amendment cases should be analyzed. What was really predominant in most of the courts, including California and the Ninth Circuit, was this test that was called, it basically referred to as a two-step test, where basically the court would first look to whether or not the conduct at issue, the law that was being challenged, even regulated something that was protected by the Second Amendment. How close it came to the core of the Second Amendment right, so to speak. And then, if it did, the court would then look to this sort of means-end scrutiny, considering the government interest on whether or not it was appropriate for the government to regulate that conduct. And so in practice, what this standard effectively did was sort of nullified any sort of challenge to a Second Amendment related law because obviously many of the courts, many of the circuits and jurisdictions are very hostile to firearm rights as a whole, and so this sort of means-in scrutiny test really gave the government a very broad deferential treatment by the courts, and for the most part, at least here in the Ninth Circuit, practically everything that's gone before the court in the form of a two-step test has been held constitutional, despite, the clear problems with the law and how it impacts a person's right to own or keep or even use firearms. And so the Supreme Court recently, now with this new test that's been adopted by Bruen, in the Bruen case, I should say, does away with that two-step means-in scrutiny test that's been used and establishes a new framework. So what is the new framework? Well, the framework that's now going to be used moving forward asks two important questions. The first question is, does the conduct regulate conduct protected by the plain text of the Second Amendment? So the court's first going to look at, is this issue in fact one that brings into question a person's Second Amendment rights? But what's different about this new framework, and this is where it gets different, is the second question, or what the court is now going to have to do, is if the conduct does indeed fall within the protections of the Second Amendment, the burden is going to fall to the government to prove that the regulation that's being challenged is one that falls within the scope and history and tradition of firearm regulations since the adoption of the Constitution. And so what that means is that the government is going to have to basically go through this historical analysis to show that its laws are in fact constitutional, by showing that, for example, this type of conduct, this type of activity has been regulated historically. So moving forward, that's a very, very different analysis than this two-step means-ends test that's been used in the past, because, for example, no longer considered in this test is the government's interest. And so, historically in the application of this two-step test, the government could say, well, this regulation is designed to promote public safety by regulating firearms, which, they use all sorts of derogatory and, arbitrary labels to refer to firearms generally. And of course, that's going to be something that the courts are going to easily find that there's a government interest in regulating. But now all that goes out the window, because that's not something that's appropriate when it comes to analyzing Second Amendment or even general constitutionally protected conduct in the first place. And so that is a huge, huge deal moving forward, as applied to all the other cases that we've had here in California. And basically what it does is it acts as a hard reset for all of the cases that we currently have pending, for cases that we've brought in the past, any and everything that you can think of: assault weapons, the handgun roster, the ammo restrictions. All of that stuff is now potentially on the table again, because all of that stuff is going to be subject to this new test. And of course, California, being the jurisdiction that it is, often likes to regulate things from novel perspectives, a novel approach, but has only been doing so very recently. So a lot of these laws that we have in California, for example, like the roster, were adopted very recently. I can't think of any possible way the government can show that we've historically had laws in the United States that have regulated handguns similar to that like we do with California's roster. So it's definitely a very very exciting time as far as litigation is concerned, because you are now going to start seeing all these cases effectively being relitigated from the start. And the government's going to have this much higher burden to prove that its regulations are constitutional, because it's going to now have to show that those regulations at issue are, of course, ones that we've had historically here in the United States. Which obviously in California, as I said, a lot of this stuff in California has been adopted within the past, 1 or 2 decades. And in the case of the New York statute that was at issue in the Bruen case, that was the statute that was adopted originally in 1911. More than 100 years ago. So if that isn't going to be viewed as something that we have historically done here in the United States, I would be amazed if ultimately any of California's more recent restrictions on firearms are going to be viewed as being historically supported by the laws of the United States.